Office of Pest Management Task Force meeting, April 18, 2012 at 10 a.m.
Yeah, and now he throws anywhere from an inning in a third to 2 innings. And so they also want him to come in adverse situations. So he almost always comes in, runners on, taking the role of what he was doing. Was it really? Yeah. True. Minor league baseball is not about winning. It's about training guys. You need to put them in those situations that you're going to have them in, whether it's hitting, pitching, catching, or defense. Yeah, they do that. Yeah. I am too. They're going to begin the first week and half time. They don't really care about numbers. They track completely different numbers than what you see as, the team numbers, ERA. They look at these strange things like strikes to balls. They want to know how many strikes to balls. They don't really care if you strike people out. They want to know how many ground balls and fly balls. They want to know how many fastballs and outballs. They track really weird things because that's what they really measure you at is how does that transition. If you can throw your fastball fly, you're breaking ball, you can't throw chart. Well, the big league they're going to go, you can't throw your breaking ball. And vice versa, if you can't throw your fastball for a strike or paint with it, then they're going to say, that's not a pitch I have to worry about. I'm going to sit on the ball. And that's always, no matter how good they're that good.
That's what I really am.
It's interesting. At least I know enough about baseball.
I was a Sam of man.
The other night he came over and what was the pitch? Did you like it? That was a good pitch. I said you should go back and look at the video. It wasn't a good pitch. I thought it was good. Go look at the video. He started it in his chest and his belt. He needs hands extended. If he had his hands extended, that's where it's all back. Yeah, you're right. You should have.
All right. It's 10 o'clock, so we're gonna get going. And so everybody could be prepared here. We'll start off with roll call, and let's go down. Jimmy Fox. Here, sir. John Bolts. Here. Ken Frederick. Yo. Lynn Evans.
Yes.
Yeah. Phil Hemminghouse.
Sir.
Dave Burns.
Here.
Will Rousseau and Kirk Smith both indicated they would not be here today. So we do have a quorum, so we'll continue on with the meeting. I guess we'll always start out with the current status of coordination, and I guess I don't know if there's a whole lot to say. It's
Yeah.
the licenses were sent out recently for all the applicators, and that went well. So everybody should have received those by now. Otherwise, we're spending a lot of time working on the statutory language and the regulatory language, which got sent out last week. And is there anything else that you guys can think of that spring up? Okay, so I'm looking at you and Robert. Casey, is there anything that? Okay, all right. If not, we'll proceed on. I just reminding everybody, if they're not a member or they're not signed up for that listserv, the addresses on the agenda, which are back on the table. If you came in before I did, the agendas weren't there. Moving on through agenda, moving to topic discussion and possible actions. I continue to put the recommendations basically that the task force has put there. I added the continuous requirement for the QP because I hadn't put that on there, and again I put that in italics so everybody will know what that is. And then we had a couple items that were asked specifically that we talked about this time, so we're going to start off with those items. And the first one being that of the record keeping and reporting discussion of requirements and recommendations. And I believe that I think it was the February meeting, we got the summary of the record keeping requirements. We discussed that. I think, John, one of the things that you wanted to talk about was the reporting requirements. And I did send out an email to all you guys just basically repeating the statutory language that covers that. And if anybody wants that, I did bring along a few copies of that for anybody that's not. Is that this one? That is that one, yeah. And so with that, I guess, John, I don't know what your thoughts were or what you wanted to do. I'm gonna give you the floor.
Well, I'm always open to that, Jack, as a topic to discuss, so that for the sake of the department and for the sake of what we're doing with groundwater protection, that we can homogenize the activities for reporting between the two without laying any undue burden on anybody who doesn't have that laid on them at present. So I don't know how you guys felt was the best way to handle that, but I did want you guys to not leave it as a glossed over item.
Okay.
That we addressed it. So I didn't know what you guys felt was the best way
to address it. Okay, and I think that's something that we should bring before this task force, and that's I didn't mean to put you on the spot there.
I pushed the issue. So
again, this was the document that we had that we passed out at the February 15th meeting, and we discussed it. And I just went through the record-keeping requirements that are required on both sides of the aisle. This is the information that I sent out to the task force, and I highlighted basic information. On the agriculture side of things, if you're soil applying a product or an active ingredient that's on the Arizona Department of Environmental Quality's groundwater protection list, you have to report that to the Department of Agriculture. You'll actually notice that it says that they're supposed to report to DEQ, but because we have the 1080 requirement already in place, we're able to have one reporting mechanism to the Department of Agriculture, and then at the end of the year, we provide that information to the Arizona Department of Environmental Quality because they provide a report to the legislature on that. And so basically, this is what it says. I highlighted it in yellow. Basically, I'm going to go down here. Soil applied means an agriculture use pesticide intended for application to or injection into the soil by ground-based application equipment or chemigation, or the label requires recommendations that the application be followed within 72 hours by flood irrigation. So that's if you're applying a product that way, you have to report that to the Department of Agriculture. It doesn't matter who you are, you have to report that. Commercial applicators, we already know they have to report everything to us. The private applicators have to report these uses to us. And finally, one more, just to put up there, this is the 2011 Arizona Department of Environmental Quality Groundwater Protection List. So this is the listing of the active ingredients that are on their list that have to be reported to us. So I think what John is looking at, one of the things that is of concern, and if I speak wrong, please, of concern is that everybody always looks at agriculture as the causing problems, and when and they have to report to help. I think in my mind it helps keep at bay that that agriculture isn't the problem. One of the big holes is that the products that may be applied structurally, in my mind, it would be more of the pre-treat type things. Would be where there's probably a greater risk of some sort of groundwater issues. So again, I'm just continuing to slowly page through the list so people can see what the active ingredients are. And we're getting close to the end. So with that, I'll open it up to further discussion as to what people's feelings are. And I think, currently in the structural arena, people are reporting the pre-treats, most of the pre-treats via the TARF. So we're getting that information and in my view, that would be a mechanism to allow reporting of these active ingredients. And I haven't gone and looked at the labels or anything like that to see whether these are used for pre-treats or registered for pre-treats or anything like that. But that was my thought. It would be a mechanism for reporting use, at least in that situation. So,
can you get the data off of the charts, put it into the report?
Yes, we could. I don't know.
The only one I saw up there, and maybe I'm mistaken, that would be used in termite work at all would be the metaclopride. Okay? Deltamethrin was another one I saw up there that I recognized. Okay. Last time I looked at it, there were three. I can't remember the third. Okay. But the metaclopride was the only one I saw for termite work. Yeah.
And John, and I don't know if that was your thought or
that particular active was the impetus for it, but also thinking beyond just structural, but whether it be golf courses and structural both, that there's probably things going on that at a minimum, just like ag, we need those chemistries, but we need to be able to establish with data that we are or aren't causing problems one way or the other, for good or for bad.
Go ahead. Please stand up, introduce yourself, and speak loudly.
Peter, JCJ, Cork and Pest Control. This is just a question, and I'm sure Jack or you guys will understand this better. Is this list compiled because they're commonly used products in ag, or are they on the list because they could be labeled for soil injection? I guess, my question is, when you incorporate structurally, are we going to start broadening that list because of soil injection?
Actually, these products, any ag use product has to go through a review by ADEQ. So whether it's soil applied or not, DEQ does a review on the active ingredient. So it's not based on use. It's just based on the fact that it's an ag use product, and they look at the physical or the chemical characteristics of the product, and if it's shown that there's a potential based on kind of what they look at to leach into groundwater, it gets put on the list and it has to be reported.
So when we incorporate structural, and I'm not trying to read in, I'm trying to understand what you're saying. When we incorporate structural into the Department of Ag, probably could be a definite possibility of that list expanding. That's kind of what I'm hearing. Am I misinterpreting what you're saying?
I would say that I would think it would make sense if there's any products that you guys apply on the ground for termite pre-treatment, they would necessarily need to be included on this list.
Okay.
you know, and one thing, I guess, as you think about pre-treats, you know, that was my thought, but the other side of it is you do a pre-treat and then you pour a concrete pad over the top of it, so, you know.
And it's not followed in 72 hours by water.
Yeah.
Well, the other thing to remember, sorry, Dave Burns, the other thing to remember about pre-treats is that they are contained. The spirit of this is really about non-contained pesticides, like in agricultural use, where runoff could play a role. In a pre-treat environment, it's most of the time it's a contained environment. There's stem walls holding whatever's there. So really the only potential risk is leaching, and I'm pretty sure data shows that leaching isn't an issue. It's runoff that becomes the big issue. That's where Oregon, Washington right now has really big problems because of runoff into streams and waterways. The whole federal Waterway Act thing is really about that.
Yes.
Go ahead, Rob. Please stand up, introduce yourself, and speak loudly so everyone can
Robert
hear you.
Schuler, representing Western Growers Association and other agricultural interests. I'm not sure I understand this conversation. This law deals with potential rich groundwater, not from a runoff standpoint, but from a leaching standpoint. And I'm not sure how you transition a pre-treatment process to being added to this list under the current status of the rules that we operate under to get products on this list. And I'm not sure where the whole issue then of monitoring for products on that list and the cost of doing that comes in if you do expand that list. So is that part of what we're talking about today?
Yeah, and you're correct. I was looking at it exactly the same way. The current setup is not for that. I was looking at if there are active ingredients that are currently on the list for agriculture, that there could be reporting from the structural side of things as well. I wasn't looking at creating a whole new structure and trying to add new products that are not agriculture use. Just looking at the structural side of things, those products that are on this list and wherever they may be applied. And I can't imagine going out and doing a treatment around a home and having to report every time you do B&G treatment.
So can I restate that, Jack, so that I understand it? What you're suggesting then is you take the existing list and the existing process by which you get on that list, which is to the agricultural side. And if on the structural side you happen to see that your product is on that list, then you somehow in the structural world have an obligation to report that to the department so that then your database is complete as to what might be being used out there.
Yes.
Okay. So you're not trying to expand the list, you're trying to take the existing list with the existing methods by focusing on it.
That was my thought.
You'll expand the information gathered from non-pets, which are weeds and golf. And that's what the majority of that product is being used right now. Most of it. I mean, 90%, I bet you, of the chemicals used for structural, 90% of it's going to be turf and landscape, weed control.
Weed control, correct.
Weed control.
Imidacloprid would be the only odd
Yeah.
that's used for termite control, and that's all.
That would be a good one to report to.
And it would be, yeah, it would be.
You're talking about current chemistries. What about looking into the future where you have additional crossover products that could fall you? I don't know if you want to make that kind of exemption since this is based strictly on leaching, not runoff.
I was looking at it strictly within the framework that exists and just adding in if we could get I'm not trying to, I'm not trying to expand our regulatory realm. This was something that has been discussed, and so I'm bringing it up here so we can have this discussion to
So
talk
let's
about
say, let me use an example. I do a pre-treatment with imidacloprid, and I use 250 gallons on the site. I do a TARP and submit that. Would OPM have the ability to red flag that or something and just goes into a...
I believe it would be an easy fix. See, basically, you check a box, there has to be a box, you've got to put a new box on the thing, you check this box, it's on the groundwater protection list, that way it's real easy to pull those in. So, I'm going to go to Vince. Go ahead, Vince.
Yeah, I just wanted to make a comment for us to get out of the termite realm and look at the bigger picture. A comment was mentioned that 80 to 90% of these deal with weed herbicide use or weed control products. So while it may be easy for us to track it through the ETAR, it's not going to be easy for us to track it with the B3 and the B5 guys. So then it looks like if this is the direction that we're going to go in, that we want to hear from those people.
Yeah, because your information you're already getting from the TARs, so it's, you're looking for the information that's, like Robert said, it's the leaching effect, not the runoff, because most of the leaching is going to be the weed control and that end of it.
Well, runoff eventually does impact
Yes,
leaching.
and that, and the leaching, and especially right now with the natural waterways and that big thing coming down.
Phyllis?
I do a lot of weed control, so I recognize some of those names.
Phyllis, Frank.
Oh, Phyllis M. Frank, it's our turn. I do a lot of weed control, pre-emergent weed control, low volume. I don't do heavy volumes, like under 100 gallons most of the time. And I also know the well drillers really well. And they're hitting water at about 350, 400 feet, at least in the Marana area. So leaching may or may not be an issue in Arizona. I know it definitely is in Washington and Oregon. And there was an issue with Princep where we thought we couldn't use Princep in Arizona. But then I talked to the chemist of Princep, and he basically explained that you don't have the same issues as Oregon and Washington.
Okay. So I guess what are I guess I'm just trying to, what do we want to do here with this?
Jack, John Bolts, I would like to see that we look at what options there are for a mechanism to expediently report and gather that information. I mean, the discussion about runoff versus leaching, I mean, these things, if they're leachable, they find their way into the water system, and I think ADQ's way of looking at it would be, they do. I mean, what through various mechanisms. But if we can gather the data, the value that Ag sees in that is that when we have the data on what materials are working their way down into groundwater, when we have the data on how much was used and where it was used, we can make valid arguments based on accurate data to make our products be able to continue to be registered. If there's value in any pest control work having the use of imidacloprid, we know the value of it in ag. I think we know the value of it in structural work and in landscaping work, that there's real benefit there. And if we want these products to continue to be registered, I'm sorry, guys.
That's a good reminder. Make sure you have your phone on silent.
I think there's value in seeing. I don't want to open a can of worms to have a ridiculous amount of burden, but if there is a mechanism that can be created where all people that are using pesticides can work with the list, and it's expanded. I mean, imidacloprid wasn't around a couple decades ago, and it is, and it's on the groundwater list, and there may be one or two new materials added a year for that thing, and it is what it is. But reporting that information in the Department of Ag, having that data, has value in maintaining the registration of those products. We're losing too many registrations for products in ag and otherwise. So I think there's value in that for those of us that use pesticides. So restricted in on it.
So what I'm hearing is that you'd like to see perhaps a statutory package to at least have some authority written into it to say that we could, I don't know how, address groundwater protection use reporting or something like that. I mean, that's just a.
I think you need to. I don't want, for the short term and for the long term. As John said, there's more and more crossover potential between the industries. I don't want to lose sight of where this stuff goes.
And in my mind, what I'm thinking is, even if we got into this, just mechanism, we could use a 1080 again. I mean, on the other side of the aisle and come into the same database. That way we don't have to reinvent any form, we don't have to reinvent any system. Perhaps there's, I don't know if there's less stuff we would need to report on there. I don't know if everything, last time we looked at it, I think everything was on there, stuff that we thought we needed.
Yeah.
But, and so I guess, there's you guys that are that are in this industry, what's your thoughts?
It's a big additional, Jimmy Fox, big additional burden of reporting if we go that way, and a lot of it with the number of PCOs and golf courses out there. Yeah. Because Phil's right, most of it would be herbicide related. And if you think about where a lot of these developments are, they're in around retention basins, flood basins, Army Corps Engineer waterways. And so there'd be a tremendous amount of reporting, I think, that would come because of that.
And again, John Bolt said, and that's not, this wasn't always the case for ag. So this was a new layer that was laid upon ag years ago, was to have this additional reporting, whereas normally we fill out our 1080 and we just file it. But these ones that are on this list, even if there's no other reason to report them to the Department of Ag, we have to fax it into the Department of Ag and report it that way. So but it has value. It has value. I mean, the burden does have a value in it, in that if we want to see these products continue to stay registered, it's an issue. And if ag is the only data that we have, and AVEQ has a monitoring well that the information that we gather just from the ag sector doesn't add up to, well, then they're going to assume that something's being misused, whatever, and it could affect the registration of the product across the board. So I guess that's where I see the value in it. So while I realize that it's a pain in the butt, I don't know how else to.
Again, just so everybody knows, I'm going to go to the committee members before I go to the audience members, and I'm not trying to put anybody off, but that's why they're sitting up here. So David and Phil.
I'm sorry, I did a little bit of research on this, and I was trying to find my notes. I can't find it, so I apologize for that. But I thought, isn't there something in there that specifically eliminates structural from that? Isn't there something in that federal piece that eliminates structural?
In the DEQ stuff?
Yeah, I'm sorry.
There probably is, because it's intended for agriculture.
I think it specifically says in there that it wasn't. So I just wanted to make sure that I'm clear on what the objective is. The objective is not saying this is saying to it, but you have a concern that maybe they might pull the plug on that part of it at some point because of your analogy that the usage that agriculture showed in the well testing doesn't mesh or doesn't match up.
I'll give you an example. And I talked about this last year, and imidacloprid was the active ingredient. And what I said is we went through and in that list that I showed, the ones that were bolded, those are ones that have actually been detected. All of them at really, really low levels. So it's not been a concern. But imidacloprid was one of those that has been detected. And so we looked through 1080s and stuff like that to find out how much of this stuff had been applied. And I went to these meetings, I was very direct about it. I said, I hope you guys are reporting. Because what our 1080s are showing is that there's hardly any of this product being used. But what we found is that it's been detected. So that means this is a really bad product. So if it gets down to it, and we can only show that we've used this little bit, but yet it's showing up in our groundwater. And so, from an agriculture standpoint, that makes you go, okay, well, we can't use this product anymore. And that's not the whole picture.
Jack,
Go ahead.
Ken Frederick again. When you say it was detected, what does that mean? Detected where? How did they find it?
We have a network of monitoring wells around the state.
So they're actually wells?
Yes.
So they found somebody active in the water?
Yes.
Now,
In parts per billion.
Yeah,
it's minuscule amount.
It's small, very small.
I understand. So your records show that this much was used, and it was found in the water, so that means it's a really nasty product.
Yeah.
That's how
That's
DEQ is going to look at it.
That's the.
Now, the question I have is, you cannot bypass private homeowners. And so no matter how much reporting we're going to be required to do, the data's not going to be accurate. Because most of that product is still applied, in my opinion, by a lot of private homeowners, especially weed stuff. So if our intentions are such, I mean, I'm not all for more regulation. So, you know, I'm not gonna be in favor of reporting it unless it's a little dot I got to make on my TARF report. Okay, I can live with it. But I don't think I'm going to be approve of anything that's going to burden businesses to report more. I have to be talked into it.
Phil Hemminghouse, the reporting from the 10E, is that a specific time after application, or is it required within the first 30 days?
Within a week to 2 weeks, depending on when it falls.
Because that, I mean, if you go to, and I, you know, golf doesn't have, you know, the amount of chemicals that they're doing is definitely not as much as what weed control or pre-emergent guys, what they're using. I mean, it's probably a group of 15 to 20 items that are all the same, but they a lot of it, so there's going to be a lot of reporting. Now, I wouldn't think they might not have a problem with it, based on the information that what it provides to either keep a product on the market, or so it doesn't take it away, because there's going to be a lot of reporting on that. Because the amount of pre-emergent in this state is huge compared to any other state. You know, this is like Surfland. This is the number one. This is the number one state in the union for that usage. And I think they would. That's what I think. If they do a lot of reporting, what are they getting out of it? What does it help them to keep it on the market? I think that's where. Because in 1080, you'll get, you know, if you just give them a month and they do it every day.
Imidacloprid is the poster child for this because we know the value of it in the various industries. I mean, it touches these pests that were hard to control before, but that chemistry is very effective at it. You know, people argue all kinds of back and forth, is it still as effective, all that sort of stuff, but nonetheless, before that stuff, I mean, in ag, whitefly was just horrendous and ornamental. It was uncontrollable, and here, over a decade later, coming up on 2 decades later, I mean, it's still reasonably to very, very effective, and the thought of losing that chemistry because of a lack of data, even if the data goes to support that, hey, this stuff's available and it can be applied by homeowners, and it's showing up in these monitoring wells that predominantly are those areas, we're showing all the data. Maybe that's where it shouldn't be registered. Maybe it shouldn't be available there. What is the issue? Or maybe we need to change how we're applying it. I don't know, but it gives us another tool. I don't want everybody to have to do a ridiculous amount of work. On the ag side, I have to admit, it's not a ridiculous amount of work. It's sticking these in a fax machine and sending them off. The ones that have a little check mark for soil applied and a little check mark for on the groundwater protection list and stuff. But I know for you guys it's different. That's why I throw it out. I don't know how it would work in the department.
So the biggest impact would be landscapers and golf courses.
Yeah, and mainly probably landscapers.
Dave?
I think we're looking at things from the commercial side of it. How do you factor in the private individual usage? Because I bet that probably exceeds most all of our usage by X-fold.
This has been the discussion for as long as I can remember, as long as Jack and I have been doing this regulatory stuff. This has been the problem with, I can think of products like malathion. We're highly regulated on malathion use, but on the other side of the fence, the homeowner can do whatever he wants. And it's a paradox that there's no good answer to. But unfortunately, in our regulatory world, these are things that we have to do, and the regulations are getting more, I'm not going to say onerous, but more complex. And the penalties are increasing for not doing them. And that's why I'm interested in having as many of these similar products included in our data, so we can keep them, and we can convince DEQ and people like that to stay off our back.
Yeah, because that might be an answer for Robert on. We go against that war to try to stop it from a homeowner using it. We're not going to. That means we have no dog in that fight, and you won't win. But like you said, they know the usage overall.
Again, Tim Gurner, JHTG, kind of working. Question on this reporting, I'm thinking the midichloprid that we're talking about so much. Is it the report, you have to report when you hit a certain threshold, how many, or is if you reply 1 quart, you have to?
Yep.
See, for our industry, that's huge. When you talk about reporting on a termite job, no big deal, but a midichloprid can also be used on a service, you know, around the home, a homeowner's home that you're charging $50, $75 for. Now reporting becomes, you know, versus a termite job you're getting paid $1,500 for. The reporting becomes onerous because your technician may be doing 12 or 15 of those stops a day.
See, but that kind of application you're talking about.
Fall into the compliance.
It wouldn't fall if you're doing a surface application.
So if there's no soil injection, you don't have
Not
to
soil
report.
injected. That wouldn't apply.
Okay, thank you for answering that.
Okay. Kevin?
Yeah, Kevin, Rich Contractors, Termite and Pest Control. Not in California anymore. I sold my business last month. Good. I don't have to drive 6,000 miles a month anymore.
Kevin, you're on
where
the
you
air.
guys are heading though is you're heading right down the road of what we call pesticide usage reporting in California. And I look at the form that you have up on the screen there, and that would be obsolete. I've got 8 weed jobs scheduled for tomorrow. I would have to literally hire another office person to fill in the form. On each day we did weed applications because we do weed applications every day and get it submitted within 72 hours. I understand that it's very difficult to argue about the sensitivity of groundwater. So I would encourage you that if you want to go down this road, and that's ultimately looks to me the way it's going, that you would come up with a simplified form that maybe would allow for reporting of total usage per month and just list the number of sites. I really would be against having to report it, period, because I agree with Ken and Mr. Burns. But I had another comment, but I've lost it, so I'll stand up later.
Go ahead, Dave.
Something I need clarification on, because I know you deal with it in ag world. Isn't there a difference between soil applied and over the top of crop applied? Yes. They're 2 different applications, correct? And one is reportable, one is not.
Depends on the product, but yes.
On the groundwater product we're talking about, one would typically have to be in the other.
As a general rule, herbicides, residual herbicides, have to be reported, even though they're applied over the top.
Because my next part of that question is in our world, in the structural side of things, we rarely do anything that isn't quote landscape, whether that's rock, whether that's grass, whether that's landscape. So I don't know if that's technically if we're falling into that over the top of something versus truly soil applied like a termiticide.
A termiticide would, if it's soil applied, if it's below the surface, it needs to be reported. In my interpretation of it.
Yeah, but where I was going with that is termiticides. I think I can see where that would be a fairly simple thing to do because we already have a mechanism in place. The one that I'm really having a tough time wrapping my arms around would be the weed control side. But how do you handle the herbicide part of it?
This, can I tell you the way I look at it? If they're applying it on turf, it's not. But if they're going out applying it on rocks, the rocks and all that stuff, that would be like a soil apply. So if you're going out putting on
you would say decorative rock?
Yeah.
Would constitute soil apply?
If you have to incorporate it with water, yeah.
They wouldn't necessarily have to for that, but I guess that's the way I was looking at it.
Make it work.
Because that's a question. You've got a field and you're going out there and you're applying it before you plant cotton, and you go out there and apply it after you plant cotton. One could be soil applied, and the other one wouldn't be.
John Bolts, imidacloprid is a perfect example for this because it can be on the ag label for the various products that are out there, generics and otherwise. There's a foliar application for control of, say, whitefly. And then
there's a soil applied, and you can apply that a number of different ways. The recommended way is normally injecting it under the soil. That's where it has its best efficacy. It's picked up by the roots. But you could apply it just spraying it on top of the soil, which has been soil applied, and then it's watered in or whatever. But if it's applied to the soil, it's applied to the soil. If it's applied to the foliage, it's applied to the foliage. And I think for the groundwater protection list, the way I've always interpreted it, it's as clear as that. That if you're spraying it almost all on the dirt, it's that. If your target is the foliage, that's different. The plant has the process of breaking it down, and it's part of the plant. So
the simple solution to this is if Robert would start getting some of these products off the groundwater protection list, we would be happy.
That's a question for the registrants. I think the registrants are going to have some interesting questions about this. I need to find out a little bit more from DEQ regarding whether or not their environmental fate review actually considers applications other than agricultural applications. So that the soil conditions, if the test of similar soil conditions or soil conditions similar to Arizona, are those considered agricultural applications, agricultural soil types, or just general soil conditions? I don't know. I'm wondering if it changes the parameters of the chemistry that you've got to show to be able to give DEQ to get registered.
That was not my intent. My intent was to stay completely within the color within the lines.
Yeah. Right.
Actually, I had no intent. My thought was to keep it within the lines. We can continue. I think we've heard kind of people's concerns and everything like that. So I guess what I'd like to, I'm going to throw this out there, and again, what we have to deal with is we have to deal. The first step is we have to come forward with a statutory package that's going to go to the legislature. And so what I'd like to propose is that we put some language in there that says something about this, and then we can deal with it through the rules. And I agree. I can't see us. I'm going out and spraying. I'm going to go and spray around this house. I'm going to report that. I'm going to go and do this. I just cannot see that happening. There's got to be a simplified way to do that. I kind of like Kevin. I think it was you that said that, having some mechanism that on a monthly basis or something, maybe the volume of products and kind of where it's been applied, even within a township or something like that, could help in this whole process. To even have a quantity limitation, yeah. So
maybe I just to go along with just your point, could it be something that is handled similar to like an RUP law, where we provided the total RUP usage versus an individual house usage? Is that sufficient?
Yes, that's what I was thinking, more of on a conglomerate basis.
So somebody could, at the end of a month, could take invoices.
Yes.
Let's say we purchased 100 pounds of X. We applied 50 pounds. I have 50 pounds of invoice. Simple report.
And 50 pounds was applied in, in agriculture, it has to be by section, range, and township, and that doesn't apply really well to you guys. But I'm trying to think of a simplified way we could do something like that. Does that seem? Would that be workable, John?
Yeah. So something that incorporates well into what we're doing, and maybe like you had mentioned, maybe attacking it from the standpoint of along with the targets if it's one of the chemistries used there. Obviously the herbicide issue is another animal, and there may be people in this side of the business that are doing lots of herbicide applications, or even a little bit, but using some of these products. I don't know, but it would have value to have it. I don't want to.
Okay. So what I'm hearing is that we'll need to put something. We'll draft something up there. I think it's going to be fairly simple, just talking about the ability to address reporting for groundwater protection. So, Casey's listening, but anybody else? Okay, go ahead. Phyllis?
Phyllis, it's our turn. If you look at what the other states are doing that have, groundwater issues like Mississippi, Louisiana, they have a really simple form. But again, they're hitting water at 60 feet.
You hit it at what, 5?
To answer that, if you look at Yuma County water users
water table in their area, it's anywhere from 3 feet to 30 feet in that irrigation district, yes. In most of the city of Yuma proper, it's anywhere from 3 feet to 300 feet, depending on where you're at. And I'm sure there are lots of places in the southern half of the state where, like you say, you can hit it at 40, 50, 60 feet. But to some degree, that's somewhat irrelevant because unless if we want to start addressing things on a county by county basis, the groundwater protection list has always been for the whole state. And although that may create an undue burden over here, we start carving these things up, it's going to be that even adds another layer to it.
Okay. Right. Okay, with that, that's what we will move forward with it that way, and we'll come back to you guys. We'll see what's in there. So thank you all for your discussion, and thanks, John. I put you on the spot again. Let's all right. Okay. Next is. I guess actually we're going to go in and start going through the review of the statutory language, and you all got a copy of that, and I'll put that up on the screen as well. And maybe what Casey, could I put you on the kind of you provided a kind of a change summary? Would you be willing to go over that?
Sure. How much detail do you want me
I don't know. Would you guys say that would be a benefit, kind of having Casey go through the quick summary change? So if we start falling asleep, Casey, you're taking too much time, okay?
How about the audience?
And then you'll come.
Here.
Go ahead, Casey. Thank you.
All right. So I prepared a handout labeled OPM Proposed Statutes Update to briefly list, and it is comprehensive, of the changes to the proposed statutes as dated April 11th, how they've changed from the draft that was dated March 12th, so that it would be easy to see what progress we've made on that. So let me, instead of reading the whole 3 pages, let me look over this and talking and kind of hit some highlights. As recommended by the task force, we removed the word structural anywhere it appeared in the statutes. We've also identified a mistake had been made with the WDIIR, so changing that name to organism inspection report. So we switched it back to what it should have been, the WDIIR. In the statutes, it had been used the term before or during construction treatments. And in the rules, the words pre-treatments and new construction treatments have been used.
Robert, you had a question or concern?
Just a quick question. If you're removing the phrase golf courses throughout, where does that put them? Does that mean they automatically fall under agriculture?
Golf courses is still an unresolved issue, and I'll just apologize up front. Dealing with the golf courses has not been my priority because I want to get other stuff done.
More field trips you wanted to do?
Yeah, more field trips, exactly. And so I have not, the gentleman is here again, I have not met with him and discussed anything about it. I'll be upfront. I personally would not like to see golf courses go under agriculture. I think there are options that we could potentially do to keep them under the Office of Pest Management, and that way we're keeping things as are, and then you guys don't need to get excited about whose money's paying for this, and you guys don't need to get excited about whose money's paying for what, or we should pay less. And so I haven't resolved that issue yet, so that will still have to come into play. Okay?
Yeah, and so to back up to that point, because of the task force discussion at the last meeting, at that point at least, it's discussed to remove golf courses. That's why the current draft removes golf courses. But as Jack was saying, that's subject to be put back in, I guess, depending on how discussions go. Again, on the before or during construction treatments, phrase that was, there was different phraseology in the statutes versus the rules. I thought the rules, the terms used there, pre-treatments, new construction treatments, were better phrases to use, so those phrases have been added to the statutes in place of before or during construction treatments to mean the same thing. In the definition of branch office, part of that definition was actually a requirement. So the requirement has been moved from the definition, and the requirement is elsewhere in the statute. So in the same things apply, it's just a way of writing the statutes. So there are several definitions that were either slightly revised for clarity, and there's actually several new definitions added that we thought would be helpful. In particular, there was a definition added for political subdivisions. The language for that was taken from the Arizona Constitution, as well as from a particular ARS statute that has defined political subdivisions. So certainly if you feel like there are governmental entities out there that do not fall under our new definition of political subdivisions but should, please let us know so we can get that added. Or conversely, if you think the current definition is overbroad and that certain words should be taken out of that, please let us know also. And so Title 48, in the definition of political subdivision, it refers to Title 48. That includes things like fire districts, water irrigation districts, pest control districts, special taxing districts, essentially, agricultural improvement districts. If you just look at ARS Title 48, there's more than a dozen different types of districts out there that can be formed, and so rather than list them all, it's first the title. So the definition of sterilant was added too. There was a definition of that already in rule, but that definition wasn't just pulled straight over from rule. It was also updated to be more accurate of what we thought it should be defined as. Well, let me just ask you, since there's along this definition, among the task force, is there any questions about any of the definitions that were added or revised rather than going through all of them?
I got a question on one, and maybe Dave can clarify this. I remember a few years ago there was a huge brouhaha about political subdivisions and requiring licenses and such. I'd hate to see that happen again. So when it says here 12-time party, added registered private owners and political subdivisions to business licenses, I mean, is it just, Kirk's not here, so is that just the intent that there's a person of a QP, but not a business license?
Yeah. I think, I remember part of it was the fact that we were trying to get a business license for a city and stuff like that, and that didn't seem to make sense, so that was part of it.
Yeah,
I don't know if there was more to it.
So yeah, the definition had said, the second part of it, that QP was responsible for training, equipping, supervising applicators of a business licensee, period. So now it says QP is responsible for supervising, etc., applicators, whether it's a business licensee or a registered private owner or a political subdivision. So in other words, it's saying that QP of a political subdivision is responsible for supervising the applicators. It's not saying that a political subdivision needs a business license.
Has that been run by the towns and cities people yet? See how they're going to react to that?
Well, historically, the real hiccup with political subdivisions came over insurance. Because they insure themselves differently and they didn't really meet the requirements that the structural laws had in place for a business license. And that's where a lot of the heartburn came. And Vince was around back in those days too. Am I right? That was biggest headache of political subdivisions revolving around that business license and the insurance requirements?
Well, from a compliance standpoint, I didn't really run into that. From a compliance standpoint, the issue was dealing with schools. We actually heard from negative comments from then Representative Michelle Reagan as to why were the inspectors going to schools, requiring the schools to have business licensing and the qualifying party licenses. So as a result, as we directed all the inspectors back off of schools, if they have license, if they have applicator licenses, we're fine.
So again, I'm sorry, political subdivision is a school district?
Well, so under the going back to the definition of political subdivision, it does include a school district. So that would require
Right there, school district.
A school district to have a QP, but not to have a business license. So the insurance goes with the business license.
So that's something that we haven't addressed then. We're still saying they have to have their insurance just like it's laid out.
No.
Okay.
Political subdivisions do not need insurance.
Oh.
Because that's tied to the business license.
Okay. Oh. All right. Gotcha.
And I know Kirk's not here, but I know he has said in the past that at least from his standpoint, being in that arena, he didn't have a real heartache with the QP side of it, the business license side of it, where they ran into more of a problem. And I didn't want to speak for Kirk, but he has said that.
I just wanted to be clear because I hate for them to come in here and start screaming. Okay. Right.
Yeah, and again, all these proposals are just that, proposals. They're subject to change still, and so as people see this, as you see it, as the industry sees it, based on more information, certainly they can change. Under 3503 powers, added equipment to rulemaking so that the director would have authority to make rules over pesticide use equipment if needed. For complaints received, this is the A3. If the department thinks it's going to file, if things are sort of violation after an inspection, this sets out the requirements for the department to notify the business licensee or applicator or whoever they might be acting against within 10 business days that there may be an action taken. It's very similar, the language used is very similar to current ag statutes and procedures for that.
Casey, Smith?
Phillips and Brenda, it's our turn. I have a question on the duties and responsibilities of powers. I don't know if I was reading it right. I tried tracking it back and forth in here. Is it your intention to get rid of the administrative hearing office?
No.
And just on that point for the task force, to be clear, the combination of Title 41, mainly Title 41 covers that requires the Department of Agriculture to use the Office of Administrative Hearings. And the department also has a general rule that applies to the entire department about using the Office of Administrative Hearings. So that would apply to OPM situations if OPM was part of the department. That's why that sort of language is not needed in these specific statutes. On B19 of powers, added a new B19 and moved the other sections down to make clear that the department can verify that somebody's actually an employee and not a rental person, not an independent contractor. So this would allow the department to get out records to prove that an applicator or QP, for example, would actually be an employee of the business and not somebody,
This is the rent-a-QP thing that we're trying to, what I've heard around here is we want to tighten up the rent-a-QP and actually get them engaged in the business, and this is to help with that.
Yeah, 'cause I think we're going back to a lot of it, just getting accurate information on time, and I think that's what needs to be. Yeah.
Somebody responsible.
We're looking at somebody at that branch, or somebody at that person, like we're talking with the, you know, the subdivision. Somebody had one person responsible there, and this was,
In section C, this is about the authority of the department to come into properties inspect, specifically added service vehicles to that to make it clear that inspectors would have that authority to inspect service vehicles. New subsection D, there's actually a related section, I did not mark the reference, but later on, the statutes, I think in the, maybe in the unlawful act section or somewhere around there, there's already language relating to about the department's ability to kind of monitor people who are in the act of performing services, and I thought it would be good to have similar language just right up front here in the power to really make that clear.
We had a couple of hands shoot up, so Phyllis?
Yeah, I can't find the section. I read it like in the morning. I know the section that the powers and duties could be expanded to looking at tax records. Someplace tax was added.
Yeah, that was the B-19 that Casey just mentioned. That was to ensure that you could tell if somebody was actually an employee versus a contractor.
Seems to me you're outside your jurisdiction and you're asking for taxes.
Okay. And Henry?
Henry Schneider, National Accommodation. Are you basically saying that it will be illegal to hire a contractor to do applications? As you know, sounds like you're requiring that someone be an employee. I mean,
we're not outlawing anything like that. We're trying to tighten it up so that we are tying the QP into the business so they're more engaged in what's going on with the business.
One more question. Phyllis, I'm trying to get to our turn. The last page, it says...
What page?
36. The joint responsibility. And it's the very last page proposed has the burden of proof provided of evidence that...
Is that in the rules or the statute, Phyllis?
It is...
Okay. Could you look at the page number again? I don't have 46 pages on.
36.
36. Okay, I'm sorry, I misheard.
Pondering of evidence that a supervised person shall produce. What was the thinking behind that? It sounds sort of more Napoleonic than...
I'm having a hard time hearing you, Phyllis.
Oh. The last page, responsible party, there was an addition, has the burden of proof.
Yeah.
Go ahead.
To me, it looks like Phyllis is referring to 3-3533 about joint responsibility. There's actually, it's not a change in the requirement, simply move the language to make it more grammatically clear. The language is identical to what was there before with respect to the burden of proof by preponderance of the evidence. So that's not a new requirement. That's something, just the phrase has been shifted. That's the only reason why it's underlined.
Okay. Thank you, Casey. All right.
Under categories 3511, we still have the same categories as last time, but the order was changed. And also in the rules, the order was made so that presently the statutes and rules, the proposed statutes and proposed rules have the same order of categories. Under business license, the B3, there was the phrase legal damages. Replace that with the phrase bodily injury or property damage. Felt like that was a better description of what we were talking about rather than the vague phrase legal damages. For the exemptions 3515, rephrase the title to make it more clear to just be license exemptions instead of persons not required to be licensed. And also added a specific exemptions for treatments in swimming pools if they're using an over-the-counter antimicrobial to treat the swimming pool. So no license would be from OPM would be required for that. So at the request of the 3516 for political subdivisions, just the task force about the issue of political subdivisions sharing a QP by intergovernmental agreement, put a limit on that, paragraph B, that they are that you can only do one political subdivision unless you get permission from the director. And that way they can't just have too big of an area, too big of coverage without the director having some sort of say over that. So if they wanted to do more than one, if they wanted to enter into an intergovernmental agreement to share QP services, they have to get approval from the director first of all. Skipping down to 3523E and 3524A.
Kevin, that's not tracking. Are we going to go back through the body of the
Yes,
statute,
yes.
or are we doing this now?
Yes, this is just kind of going through with.
Okay,
Yes.
thank you.
The language, this is language about getting in-house training and made it clear, change the language to make it so that you wouldn't just have 5 hours of training from any business that you formerly work for or your current employer, that it would have to be from your current employer. Where is the case?
3523.
There's two spots where it has similar language. So it's 3523 paragraph E and also 3524 paragraph A. Just an ever so slight rephrasing in the language to make it so the training has to come from your current employer. You can't, in other words, you wouldn't be able to say, oh, I got that from an old employer, several years ago. Also in 3524, there had, with the category that's proposed of simply doing wood destroying insect inspection only, it has to be clear that those people could also do a WDIIR, so that language has been added in to allow them to do that. And then paragraph E of that same section has been added to prevent somebody from, for example, filling out a WDIIR for their own house. So then on 3531, B17, there was a concern about access to records and that maybe the department, the inspector came to your business office and wanted to see records of the employee there, might not have access to that record. So made clear that it would only apply that the employee only had to give up records on the spot if they actually had access to those records. Oh, then in 3532G, this language, and taken from similar groups under Title 32. The idea is that if you currently have a license, and the department is taking action against you, somebody might come up with the idea of just letting their license expire in the meantime so that the department can't revoke their license, because revoking the license has some extra consequences to it. And so in this situation, this statute allows that if they just try to let their license expire, that the license does not expire, it temporarily holds over, although they can't act, they can't go do business under this license, but it allows essentially the department, if the situation is right, to still revoke the license and not let the person get out of revocation by failing to renew, and to keep those consequences that come with revocation in play.
Okay, question, Rick?
That's just like a tail on an insurance policy.
Stand up and
Sure.
introduce yourself, please.
Sorry. Rick Ruffke, University Termite and Pest Control. That's similar to a tail on an insurance policy, where the insurance covers you even after you are out of that business or beyond the time limit that you're under that insurance policy. Is there a time limit that phrase or clause applies to? Is it for 1 year after you are no longer licensed? Is it for...
It's if they've been advised in writing that an investigation or complaint is pending. If they haven't, it doesn't apply.
But it applies forever if that's the case.
No, I guess... I guess... Oh, go ahead.
Yeah, no, essentially, it's already a rule. R429702G specifically states that if a person is under investigation, so this applies if a person, like, let's say the person is already licensed. We open up, we notify them of an investigation, whether an inquiry or complaint. And they know that they're in trouble. They have a license currently, but then they say, you know what, I'm just going to let my license expire. Well, because they were informed or notified when they still had their license, that's when it stays. But like, if their license is already gone, from my understanding, then it does not apply.
Jack, to specifically answer his question, isn't there a time frame that an investigation, once open, has to be closed?
Not on the OPM side.
Is that something that we're bringing over from the ag side that would address and answer that question?
Well, actually, the language currently proposed says until the investigation or complaint is resolved. So if the investigation comes out and says yes, violation, then at that point, and yeah, we want to revoke you, at that point it's being resolved. If they comes out and says we decided to give you a warning letter that there was no violation or whatever, then at that point it's resolved too. So it's not a forever thing. It's just why that investigation is pending. Then it holds over.
But in a previous task force meeting, didn't you mention that on the ag side we had a specific time frame?
We have 6 months.
6 months. But if there's nothing on OPM, I mean, maybe there should be a time frame that addresses that. That would answer that question specifically.
I just want to say we currently have a case right now, and I mentioned it the last time we were in this room, where we have an applicator who was issuing bogus WDIRs. Because the applicator now has an attorney, we've gone way beyond 6 months. But yet we have to keep that case open until we can somehow get the information that we need.
Six months may be too short a period in that example, but I think there does need to be some time limit. It can't be an in perpetuity type thing, or I'm not comfortable with it being an in perpetuity type thing.
Okay. All right. So that was kind of a summary of all the changes. So now, and I also sent out Kirk Smith. He had submitted a few comments. Some of them I agreed with, other ones I didn't agree with. He's not here to defend himself, so. Let's see. I want to get the new right here. We won't there. All right. So with that, we have the package, and I'm going to ask if there's anybody wants to talk about any page in specific, and again, I want to, as we speak here, please realize that we internally continue to look at things and make small changes and everything like that, and so this is still an ongoing process. If you've got specific issues that are problematic, make sure you let us know, and we'll see if we can address them. So with that, does anybody have anything specific they want to get to?
Jeff, I had one thing specific.
Okay.
John Bolts, on the QP,
Is this rules of the law?
well, it kind of overlaps into
Okay.
both, but on the QP, from the aspect of the specific provisions that are written directing that individual for how they're supposed to accomplish their task. Originally, I had expressed concern when we first opened this can of worms up about those specific items, like has to be present at a location at least once every 30 days, that sort of thing. And I had a lot of heartburn over that because I didn't feel that any person could effectively accomplish what they were being charged with doing by under that protocol. It gives minimum requirements. At the same token, on the other side, the nuts and bolts of the requirements of the QP and where they would be, what they're responsible for, as spelled out, obviously is a driving factor as well. So I don't have particular heartburn over the way it's set up. We've resolved as a group to stick with the QP and that name and that situation, and not to go back through and rehash that, but specifically to that language that addresses the 30 days and how we're saying as minimum requirements. Are those sufficient minimum requirements? And certainly on the other side, I'm in agreement with how it's drafted up, how Casey has it drafted for the practical application and the responsibilities and duties. And even on the joint responsibilities side, I like that. But as far as the specific minimum requirements, I just wonder if we're paving the way for somebody to be in this QP position that's ensuring safety and training and equipping that they're there. So, and those requirements were basically back very similar to where we were when we started. So I'm just asking a question of the other.
Do you have a suggestion of what you'd like to see, or?
I don't know. Originally I was an advocate for getting rid of that and making a person that works in that location responsible for those things. We went a different direction, and I'm not here to rehash that. I'm curious how a person who's responsible for that, this world that we live in, sometimes people become minimalists in all the wrong ways, and my concern would be that somebody is responsible for that, albeit the department's going to take them to task in the event that there is an issue. But if our intention is to set up conditions to where we have good mechanisms, we're not creating issues, how is that QP going to effectively do that? So when you ask, do I have something specific in mind, I'm not in these guys' business, so I can't say, but and it also did specifically direct the lining out of procedures and policies, and I get that. But physical presence is a big deal for these things. It wasn't specifically notated that the QP would be, would need to be there. And I might have missed it, but need to be there for an inspection. If you're notified that you're going to have an inspection, although he may be culpable for it. So that whole QP thing is very loose reins to me on as compared to what I see as a practical application of ensuring safe use of pesticides, both for the applicator and those people that live and work around where it's being applied. So,
and that's
if everybody else is comfortable with it, not to interrupt. If everybody else is comfortable with it, I'm good with it. But we're basically right back where we started.
I'll tell you two things where I think we've tried to tighten it up a little bit. First off, we've got the, branch supervisor and bringing them into the responsibility. So there's actually somebody at each location that, they're under the qualifications of QP. And in regard to, again, what Henry was asking for, if we were breaking the law regarding outlawing contracting, and that's not the case. We're trying to ensure that that guy is part of the business. The QP is actually working for that business. I don't care if they're a contractor, as long as they're engaged in the business itself. If they're engaged in the business, I don't think we have to set the minimum standard, and that's at once in 30 days. If they're really engaged in the business, they're engaged in the business. And so what we're really addressing here are the bad operators. And we tried to tighten it up some, but we also didn't want to make it so impractical. And we said, we had started out saying, okay, we got to be there once a week. And then we're going, it just, so.
I like the clarity of the joint responsibilities, and I like the clarity of the branch manager, and I like some of that. I'm a little bit perplexed that while drafting this anew, we're back at the same point, to some degree maintaining the status quo. My concern was, the whole package. Everybody's responsible for safety, but if under law and statute we're going to specifically name, but if there's one guy that is clearly responsible for, it's this guy, and he only has to be there once a month. I don't even golf once a month, so I don't call myself a golfer.
I just have two things that I think the task force is working towards that. The first one is, I think when you adjust that 3,000 hour hurdle and get it where it's more realistic on a person being able to get QP, I think that changes the rent a QP version right there, because now a person's more apt to be able to qualify and go get his own QP. The other thing is, I think you're talking about a minority of the people, because remember that the majority of the companies are like Ken and myself, where the QP, we are the QP, we're the business, we're there every day. The other ones that you're talking about really are a very, very small minority. The vast majority of our companies in pest control are 1, 2, 3 truck operators. That guy's involved every day in the business. Maybe a lot more than he really wants to. But that really is the case in most of them.
More than they encourage it.
All right. Okay. Go ahead.
Henry Schneider, International Accommodations. I have to agree with John that somebody showing up once every 30 days is just simply ludicrous. He should be, if you're going to require a full-time QP, and I disagree with the concept that you need one for a lot of conditions, but if you're going to require him, he should be a full-time employee, and he should be there every single day, with few exceptions. He should be like any other employee. He should be required to show up and do his job on a daily basis. Once every 30 days is just simply ludicrous.
Okay. Kevin?
Statute?
Yeah, that's what we're talking about.
Kevin, after your contractor's term, any specific page, or you just run it through?
Yeah, I guess I was just wanting to see if there's anything specific. If not, go ahead. Go for it.
Specific.
Page 4?
No, 4 specific.
Okay.
Got permissions.
Yeah, come on up to come to the podium, then you can set the paper down too.
Okay. On page 5, under 17, you've defined integrated pest management. Is there any reason you just didn't mirror the EPA's definition of integrated pest management?
You're the statute. Yes.
And Chairman Peterson?
I'll just look at that. Thank you.
On number 18, under new construction treatment, I know that we don't have a huge drywood termite issue in this state, but do you want to consider including drywood termites and other wood-destroying organisms?
Actually, we talked about that internally, and we probably are going to change it to termites, not just say subterranean termites. I'm not sure what page you're on. That's the general.
5.
Page 5. On which number? 15. 18.
We're in statute, am I on the right page?
Oh, yeah.
Page
yeah.
5.
Number 18, new construction means actually, I think we changed that to wood destroying organism
Okay.
in both spots, so.
Wood destroying insect, you mean?
Again, this is statute, so I think this is going to be organism. That was my recollection of this.
Okay,
New construction
that's
trees.
not mine. I thought we changed all organism back insect.
No, not in the overall authority, because we were leaving it broad enough, so if we had to address it later on, we could. And we're going to call it WDIIR and insect inspection and stuff like that, but not, we're looking at this on a broad basis, so. Robert?
And unless I'm mistaken, I think at least for number 18, which I think the stretch was actually thinking about, is I think we actually just removed the word subterranean and just left it as termite. And left it, and actually didn't change it to wood destroying organism, but definitely did remove subterranean, just left the termite, so it includes termites, because that's where the treatment is actually being. That's the general purpose of that treatment.
I bring this up nearly every day.
Yeah. Appreciate it. We'll,
Jack, can I address Kevin's question about integrated pest management? I think that the EPA's definition is essentially, this is a shorthanded definition of that.
I agree.
I don't know that definition includes organic foods. I don't think that belongs in this.
I'm sorry, I'm just talking about the top paragraph.
Oh, okay. But it, in my view, is essentially the same. This is a little more economical.
I just bring it up for conversation.
But it's essentially the same.
okay, all right.
On page 16, under your new C,
Okay.
when you're talking about wood destroying insect inspection, and I believe this was just taken out of old statute with the $100,000 limit. I don't think $100,000 nowadays will buy you a cup of coffee and get you out of town. I'm wondering if you should perhaps increase that to $500,000.
That's under C, did you say?
Do you mean little
Small
C?
C?
Small C. Oh, small C, I'm sorry. Okay,
3C.
Okay, there it is. All right.
Sorry.
Yeah, and that's just me, because I'm thinking ahead too, because there's something else I didn't want to forget, so I'm listening, but trying to make note. Robert, do you have any feel for what we're getting in?
Yeah, in dealing with some of the smaller companies and some of the insurance companies, obviously the 100,000 is a minimum that we have said, okay, we'll leave it at 100,000. I know that when I have new companies coming in and they say, hey, well, you know what, I'm going to get the minimum, I've been able to explain to them that typically most people won't let you on their property with the minimum. So you can get it, you probably won't get the jobs you want to get because you have the minimum, but that just means that we're not saying you have to get this absorbent amount. You're more than welcome to get it. We're just saying this is the minimum that we're requiring. Industry's going to drive what the actual cost is going to be, or what the actual limit's going to be.
Yeah, I'm not going to put it. I was going to ask everybody company insurance, but then nobody wants to do that. I guess what are you guys thinking about that? I'm trying to. What is agriculture again? I just don't. Do you remember what ours is?
Basically, the applicators, whatever they can get. Poor guys.
I didn't bring my ag statutes.
I got it.
Yes, indeed.
We have one spray rig and we carry 1 to 10, so it's 1 to 10 in aggregate. No.
Oh, okay, so you're way.
Yeah, I don't think there's a limit on ag. It's destroy
There's a
that.
minimum.
Yeah, it's
The value of the crops you're spraying,
Yeah.
the value of the crops around you.
You can't afford to buy.
you can't.
Okay.
How much that whole crew load of people that happen to pull up next to your field is going to sue you for when they got out and they shouldn't be busted.
Yeah. So,
Jack, if I can, while you're looking, if I can ask a question of Robert?
yeah.
How many of the policies do you come in? Do you see a significant number that come in with 100,000? The reason I ask that is I'm not sure that there's very many insurance companies that even offer that level of a policy.
I would say as far as termite, this is specific to the termite, almost none. I can say probably in the last 5 years, I may have had 2 companies that started out at the minimum and quickly bumped up because they just couldn't get the work because their limits were so low. And again, speaking strictly of the termite category or the wood destroying insect, wood destroying organism category, being that $100,000 mark there is just as if that's the bare minimum that we're saying. I mean, I know in dealing with a lot of the insurance companies, they're above that.
And so the question is, I mean, really what Kevin brought forward is probably a good question. Is $100,000 enough? You know, and not to, I don't know if there's.
Well, I've been in business for 30 years, and I have never been sued for less than $100,000. It's always greater than. I've been sued twice in 30 years. Both of them have gone over that mark. So
you've been screwed up.
You know, it seems to me that even in agriculture, we have a higher requirement than that. In my mind, it seems like it's $300,000 or something like that.
I say area was 250 or 300,000.
Yeah. So
food for thought.
Yeah. Okay. Appreciate that. That's
all right. Page 23 under 3-3518 fees. In your item 1.
I'm sorry, what page?
It is page 23.
Yep.
3-35-18 fees.
Yes.
And item number 1, business license.
Yeah.
$5,000 threshold. I did some quick modern math. You have about 1,400 business licenses.
Yeah. Well, right now we're at 1225.
Whatever. That's all too hard for me to compute, so I just used 1,000. Jack, if you retire or go away, the next guy comes in and says, you know what, I'm going to blow this to a $5 million a year agency. He could do that pretty easily, and we have proven on the PMAC side that we're actually decreasing expenditures. So I would encourage you to lower that figure.
Do you have a recommendation?
I'd go $2,500. That still gives you $2.5 million. But then you have to take TARP away. I'm sorry, that's another.
Okay, all right, thank you.
Sorry, that's not in the statute.
And off again. Okay, page 30. And this is probably because I can't get this through my thick head, but under 5B. And I hope I'm completely wrong. But the way I read that is, if I have 5 hours of instruction, I can go out and fumigate a house. Am I wrong?
No, this is this is for the applicator. They have to receive at least 5 hours from their employer.
Right. So, but they have to be licensed in that category, correct?
Yes.
Okay. So in other words, you got to have at least 5 hours of instruction.
In the business you work in.
From your current employer.
Current employer.
I'm not comfortable with that with fumigating. Because you're going to spend, and I don't mean this to be condescending, but if you've got a really good fume crew, you're going to wrap in an hour and you're going to shoot and be on your way. The reality in Arizona is that I've seen wraps take 2 or 3 hours. You're basically clipping parts together and dropping sand snakes. You are not dealing with the fumigant for but 15 minutes of the shoot. I don't think 5 hours. You could claim you were on a fumigation job for 5 hours, and you may have only actually had 15 minutes of instruction actually handling biking. Okay. So I would eliminate the word fumigation. Thank you for your time, Joe.
Thank statute that you want to look at?
Well, I'm trying to find the new one. I brought the old one for our last meeting, so I hope it's the same page number, but it's 33515, if I got it right. Page 19 in mine. But like I said, I got to look from last time. It has to do with the person not required to be licensed under this section to apply pesticides on commercial property that a person owns or occupies, or on a residential property that the person owns, and which another person occupies, provided both. I just have concerns over how far that's going to go. The private owners can be able to do pest control in a rental property, but now I know it says here that they have to be registered with the department and they have to hire a licensed applicator. They have to have financial security.
Yeah.
They have all that.
We're requiring the same thing of them, we're just not requiring a business license. They have to register with us to show us that they're falling under that exemption, but they have to have the qualifying party, they have to have the insurance.
Why do I have to have a business license then?
Because you're going to offer your services for sale. This guy's just going to be flying on his own property. I mean, that's the way I'm looking at it. Go ahead.
I just have one small comment that probably should somehow be addressed in there if you're going to run down this road, and that is in statute there is the ability to charge a resident money for a service. Specifically that that's in statute.
So that's like the guy making his own WDIR for his house before he sells it. So this is kind of a self-made.
Could
what
be.
you're saying it's a self-made.
I don't really want to run into it. I think it's just something that somehow needs to be addressed because you do have the ability to make that profit center within your own company that ultimately a resident has no say. If it's $1,000, it's $1,000.
Statute is on that.
No, I don't, but I'll get it for you. It was through multifamily housing is the way I know about it, but I'll get you the statute.
Thank you. That's a good thing to make sure we do. Go ahead.
Fred Willington, Bader Pest Management. The same issue kind of likens back to what about the rent a QP too. So you got a big apartment complex and they want to do all their own work and it's quite expensive. So they rent a QP, and now we're going to create the, what we're calling it, the qualifying applicator now. So the applicators can basically have a QP license, but they've gone through all the training and everything. So it actually opens the door for them if there's still a way for them to be a rented QP basically for now a hotel. So they can work for us full time over here and then another QP in for a apartment complex. So I think there's a little bit of concern there that, any place like that, that was kind of my wording too. Or I was concerned about the wording about,
Public political subdivision?
Yeah, something, that other one that didn't have any sense.
They can only work for one, just as it is now. You can only qualify one.
Right. But you figure, let's say I have an employee and I get into that next status where he could become a qualifying party. So now he's a qualified applicator.
Yeah.
I put him through the school training and everything like that. But he works for me as a technician basically. But now he's QPing over here for some place that's paying him $4 grand a month, which is a lot cheaper than, doing a dozen bedbug treatments. If they were to pay us for bedbug work. So I don't know, can he be a technician and a QP for somebody else?
Go ahead, Robert. Mr. Willie, there's nothing to preclude that now.
Yeah.
We have plenty of applicators who have qualifying party licenses. They work as an applicator for one company, and they either QP their own business, whether it be in the weekends or, after their normal shift. But that's something that happens now. I've seen it where companies have specific policies that prohibit that. I know of an applicator who let his QP license go because it was either that or he no longer had a job. And that was based on his company, the company he worked for.
But we just got done saying that we wanted him to be full-time, basically a full-time employee versus a rental QP. So, the door is still open, I guess what I'm saying, and now it could even be worse.
We'll have to look at that. I guess I don't see that any different than it currently is. But is it counterproductive to what we're actually trying to do?
That's my point.
Okay, thank you. Anything else? Go ahead.
On
Dave.
page 37, 3-3535, I would like to see, this basically deals with someone who has a license suspended or revoked from the department. I'd like to see something that puts a little more teeth in that, so that maybe the agency suspends that name from usage, so that a person really can't go back out under another license or somehow other involvement and get the ABCXYZ company and put that back into play 3 months later or 4 months later under another group of individuals. I think it's fraudulent in doing that, but I just would like to see something with some teeth in there that maybe suspends that, and it gives the agency the ability to suspend that name for a period of time. And that would be something that was suspended or revoked.
Don't you have the ability to do that with the name?
You're getting out. Remember, you're getting out of the naming
Yeah,
business.
yeah.
That's why I thought that might be
I thought I
appropriate
read
to
it.
put that in.
I thought I read it in here again.
Well, it says if it's misleading.
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 They can do that. In this situation, it would be misleading if it's still the same name. And I guess what we're trying to do is they actually explained this to me just yesterday, was that we're trying to make sure that the person who's kind of the bad actor in that whole group, can't just all of a sudden, okay, we'll start up a new company, and now I'm the QP for the same company, I'm still doing the same thing, I'm just not, and what you're saying is we ought to be able to somehow kill that company name as well, so they can't.
Branding is a huge value.
Yeah,
So,
I mean, what I think has happened in the past is they said actually that this person kind of got pushed to the side, sort of, and the rest of the employees or whatever came in and got the company going, got the name or something, and went that way. Isn't that what the?
Eventually, it's typically when you have a company that has a situation where they've had that, typically people don't want to go to that name anyway. So the name's not necessarily the problem. It's actually the people that are involved. And we all know names don't create violations. It's the people. And so what we're trying to do here is say that if you were the business licensee or the qualifying party to this and the license was revoked or suspended, you couldn't then be hired by somebody else, go and get all those same customers back, and you be the QP for that new business. Regardless of the name, because it's the actions of either the principals or the qualifying parties that were the ones that caused the problem in the first place.
I have a question for Ken about this concern. The way I see, at least with the naming aspect, with the suspension, that business license is suspended, so no one else is going to come and get that name. That name can't be used because it's suspended. Now, in a revocation situation, that business license is now gone, and conceivably somebody else could try to pick up that name. But if it's the same players, then they're going to be blocked from getting any sort of business license under any name. So they're not going to be able to use the same name. They'd have to sell the asset, sell the name to somebody completely new to be able to use that name. Now, in that situation, where you've got all new players, but they want to buy the asset, buy the name of an old company, do you want to block that too? Is that part of what you want to do?
I don't necessarily want blocking. I just want to see something that the agency has the ability to look at, something that says this isn't right. You can't take the same group of players minus the guy that got hit the hardest and go collect on the assets and be in business the next week. And historically, we have seen that in our industry.
I think we're attempting to do that with this, but we'll talk about that when we go through the next gyration or so. Okay? All right. Thank you.
Just a point I want to bring.
Okay.
John Bolt's forward on that subject.
What page?
On that same page, 30. well, I guess on mine it's 38, but in 3-3535, capital B, principal includes an owner that is itself a business as well as an owner of a principal. What am I missing?
That means that, for example, the owner of a business is a business, and you look back another level and see who the individuals are that own that parent company. So basically, it keeps going back till you get to individuals. It doesn't let you provide a corporate screen.
Gotcha. Okay.
That get around
multiple corporate. Gotcha. Okay.
I wasn't, because I read the same thing.
I read it earlier, and I wasn't going to ask about it because I figured it made sense.
Well, we all asked about it too, so.
Okay.
Okay?
That's just trying
And I know that the time is passing away, and I saw a gentleman leave. Please make sure everybody signed in and when you came in, so we have a record. And again, I didn't say anything about the fire code. We're soon to be dismissed, but if they had a fire alarm, and you leave, but don't disappear, because then they have to come looking for you. All right. Any other sections that people wanted to? It jumps up at you. So what I'm gathering is we're getting pretty close with the statute, and we're still working on the rules, and we're making some changes, and there's still some things that we have to. I think, and Casey brought these up yesterday, and I appreciate that. Is we still have to talk about devices. Devices is going to be a big discussion, and how are we going to deal with that? On the one hand, you got the guy that's going out there and putting up the nets to keep stuff out or keep bugs out, and then you got they're caulking in houses, and then the other one you got where they're you look at bed bug control. So there's things we got to look at there. Golf courses, I know I still need to address that. We need to deal with, there's some trust fund language that was passed this year, and if we want the OPM fund to fall within that, we have to meet some certain parameters.
Should have brought that up 6 months ago.
What's that?
Should have brought that up 6 months ago.
I thought you were going to cover for us. And then, in my mind, I have to make sure that we're all clear on the wood category. We're looking at having subcategories, and you come in and you get the category, you're good for everything. Or if we have people that come and just treat power poles. Should they have to go through all this stuff to go out and treat power poles? And we have people who are just doing the inspections. And we were looking at that as being kind of separate tests just for those things. So I think that's still some areas that we need to discuss and come to a conclusion on. We haven't started getting into the regulatory side of things, but we are working on it internally, and hopefully you're seeing the changes and taking the time to take a look at them that go along with the statute. And if you have comments on those, please feed them in. I mean, we'll try to write stuff in or address them as you have concerns, and then we can talk about them here in the meeting. So again, I reiterate: if you are going to share them, you have to share them with me. You can't share them with the entire committee because everything we do has to be discussed publicly. Okay. With that, it's 10 to 12, and so I guess what I'm doing is I'm looking at moving along in the agenda just because we didn't get into the regulatory stuff. But and we do have something on the agenda that I would like to talk about. I don't know if everybody remembers it. One of the things that's been problematic in the past is the verification of experience. And at one of the previous meetings, I passed out actually, I think I brought some copies along this time, just because I wasn't sure if people would have that. And then, okay. I See if I've got that on my computer too. I don't think I pulled that one, darn it. Let's see if it's on my computer. Basically, we looked at California, and actually, Kevin, you had mentioned this before, that California, they have a form that basically you have to fill out. If somebody comes into you with a form, you're required to fill out the form and basically verify somebody's experience. Right now in Arizona, that's one of the issues, is that they'll go to their old employer and they'll say, I'm not going to verify your experience, because they don't want them to go into the business and be in competition. And I understand that. So we were looking at a regulation that would require, similar to California, if you had an employee that came in and they give you the form, you would have to verify that they had worked for you, and kind of it gives a description of what they had to do. Casey, I don't know if you actually put this together for me again, so I don't know if there's anything that you recall from that. That's just done, Casey, too. And not putting, Kevin, is there anything you'd like to add, because you got me onto this, and I'm not trying to put you on the spot.
That's the second time you throw me under the bus.
Oh. you had said
Kevin, after the contract, basically the California requirement is, if you're an employer and somebody wants to obtain their operators, the equivalent of our QP, then you have to verify hours, and you're not allowed not to verify hours. Now, you don't have to falsify the form if the associate or the past associate or present associate brings you a qualification form and it's filled out. The way it worked in my business was I would hand it to the bookkeeper. She would check payroll records, because sometimes a guy would come back 5 years, after he had worked for us. So we'd have to go back and look at the payroll records to verify that he was there from January of 2000 to July of 2001. She would fill out the dates that he worked for us, and I was required to sign the form as the operator. Pretty simple and straightforward.
Is there a limit on the years back? How far back? For a check? Or could check?
I can't speak. I don't think so. I think Harvey, California, experience is experience, right? No.
Casey?
So just to respond to what you asked me about, I think this sheet that was passed out. The current law requires, it has a 3,000 hours, generally speaking, requirement. 3,000 verifiable hours. The last that the task force talked about this issue, we had a 0-hour requirement, simply just a 2-year requirement. The proposal that Jack is offering is, and that this language relates to, would have, in addition to the 2-year requirement, for a QP, would have the, or I guess this would be actually QA, the qualified applicator license, but would have the 2 years plus 500 hours, so that there's some
that was when we were talking about too. That's licensure.
Some sort of experience requirement, so you can't just hold on to your license and do nothing with it for 2 years. And then coupled with that would be a requirement for the business licensee to keep employment records for 5 years, and then to provide verification of that employee's time going back 5 years as requested. So that's what the language is for.
Thank you.
Go ahead, Dave. I kind of got lost there, Casey.
So the proposal would be a annual time verification only, correct? So if Jack worked for Dave Burns, I just have to say, yeah, Jack worked for Dave Burns from January of 2005 to January of 2006, 12 months. No?
No. This particular language relates to verify not only that they work for you, but that they work 500 hours in a particular category.
I'm going to struggle with that one again, because that's no different than the 3,000 hours. It's forget the 3,000 number. Verifying somebody's work a number of hours is a difficult task, because you're asking me to put my name on a line that says, I know you worked that. I don't necessarily have those records, especially when an individual might be a commissioned person where we don't necessarily track every hour worked, or somebody that may work somebody as a in a subcontract type situation where they're just paid for by the job or whatever. Those people typically under the quote subcontract category, that's one of the requirements is you don't keep track of hours. There's the 7I exemption rule that pest control and some other service industries fall under, for payroll, that you only have to keep track of hours a certain way. That being able to track that hour is a difficult thing for a business owner. And that's probably what is more cumbersome, more painstaking than any part of it. It's easy to verify a date range. You work for me from this date to this date, and his what he does. Those are pretty easy that I think most companies can do.
You could say that he had a route. And you know a guy had a route or something like that, right? He did.
Sure.
Okay.
Yeah, but in most cases, I think, and I'm going to speak in generalities in companies, and Ken can tell me if I'm right or wrong, and Kevin, you help me too. But I think in generalities, the things that you absolutely know for sure is the date of hire, the date of end, and what they did for you. They ran a pest control route, or they were on a termite crew or a fume crew. You usually know the department or area. In some cases, in a really small company, that guy could be doing both. He'd be doing pest control in the morning and termite control in the afternoon. That's not an uncommon thing.
I guess in my mind, at least, that's kind of what I was thinking we wanted.
Yeah.
I wasn't looking, personally, I guess, I wasn't looking at more than that. Looking at saying the guy worked for you and this is what his responsibilities were. You ran a route. This included general termite control. He'd come in and he'd do general pest control, and also he'd do termite when he was on a termite crew
and that's my point. Is I think that if you're asking business owners to verify hours, that is a complicated task to say this guy worked from 8 in the morning till noon doing GPC, and then from noon till 4 he was working a termite job, and then he went out and helped the fume crew tarp a house, or do weed control, and he spent 15 minutes doing that.
What you're saying, the hard part is actually saying what I can verify that he did 500 hours, he was doing this and this and this, and in my mind I was looking at that. He worked for you for 15 years, and in those 15 years he was responsible for doing these activities, and out of that we ought to be able to get that he's got 500 hours of experience. I mean,
You might be able to get that, but you're asking me to sign off that says I know that. What happens if at some point I don't have the ability to verify that? And
well, it's 5 years. It's 5 years, and I think that would all come in how this whole thing were worded to see if you were comfortable with it.
That whole hour thing just continues to give me heartburn. I didn't like 3,000 hours, and I don't like 500. I just don't think...
You like the flat 2 years of license?
Well, I like some form that is measurable by the small business owner.
Okay, right.
Yeah, I just don't see the worry about experience, because no one's going to get a license and sit around for 2 years trying. Not many. And I'm not worried about training the law because, well, that's not a true thing to say. But in reality, I don't... It just feeds the argument again that people are going to say, my employer is not helping me.
Well, and again, it's he also had to pass the test, which we should have rigorous enough that in itself should maybe preclude the time frame.
Okay, right. There's several hands go ahead.
Tim Jordan, JHTG working. I guess I'm questioning why we need the form. Every year when I renew my business license, on there is a list of my employees, and I have to verify if they're still working. So if we don't have an hour requirement, and it's 24 months, and I've checked that box for 3 straight years that said that Joe Jones worked for not even really sure why we even need this form that verifies what I've already indicated, when I renew my business.
I think, go ahead, Robert.
Well, with bringing back registered employees, that would be, I think, a viable option. Right now, it's not required. We provide a list to you kind of as a courtesy. You can say everybody's still there and nobody's there, and that's your option. There's no requirement for you to actually do that. We just provide it so that you have that option. A lot of companies want to be able to list their employees on there, and if their customers want to look on our website to see if, oh yeah, this guy actually does work for them, that's actually why we do that. But it's actually right now, it hasn't been legally required since 2003.
So I guess, and maybe, there may be some complexities within the department I'm unfamiliar with. It seems to me that it would be a simpler solution to just make that a requirement than creating
Okay.
it.
All right. Oh, we have a gentleman standing already. Go ahead.
Chris Miller, beekeeper. I think that having employers verify employment dates is a relatively easy matter, as Dave has indicated. But if you look at the way Register of Contractors does it, they don't ask for employers to verify anything. They ask for the employee or the applicant to verify by submittal of W-2s, pay stubs, some sort of verifiable documentation that they've received from their employer, and they put the burden on the applicant because, after all, they should be keeping records if they, and something that they can submit to prove their own case.
Okay. All right. Thank you. Appreciate that. I like that.
Kelly Denny with Metro Institute. Then another piece, Dave, would be that not just the employment time, but during that time you're certified in the category that you're operating in. And so that's a second piece of confirmation. So if it was like Robert was saying, a registered employee, one time you put him in, and when he leaves, you take him out, you would have every information you would need.
That would make it simpler from the standpoint of doing it that way. So. Okay. All right. So I'm not hearing an overwhelming wave of support for this. Sorry, Jack. So thank you for your response to that. I guess I printed on both sides.
Where's the paper there,
So you want it back. Okay. Got through that. What we're going to do then is we're going to future deadlines. I guess I'm just going to throw out that I really think that we need to have this fairly wrapped up by let's see, where are we now? We're April, so we got May, June. I'm hoping by July that we're going to have this in a tight enough form that people feel comfortable with it. So keep that in mind as we're moving forward, so that everybody can get out and, if they want to talk to their legislators and let them know what's going on, and because this has to go to the legislature to make a decision on it. So go ahead, Robert.
Robert Schuler. Jack, is this going to be a Department of Agriculture bill?
No, the task force is going to submit a report to the head of I'm guessing Speaker of the House, President of the Senate, and to the governor, if I remember correctly.
So whose bill's going to be?
I don't know.
Is it going to be a Department of Agriculture bill, or is it going to be an industry bill? And the reason I'm asking that is because if it's a department bill, then it's clearly going to have the governor's
approval. Yes.
So I'm just curious. I think that's a critical point of understanding before you go much further.
I was going to have that response say whatever the governor tells us to do is whose bills it's going to be, but I held myself, but I said no anyway.
Strike that last line.
So I guess I think that will be an issue that gets worked out as this process moves along. Honestly, if the governor says it goes one way, or the legislature says it would be good to go a certain way, we'll do that as directed by the Speaker or the President.
I think they're going to look to you as the industry for direction.
Okay. Well, you want to know my choice? If that's what you're asking, my choices? My choices would be it's an industry bill. Because an industry bill is something that the legislature doesn't look like a bunch of bureaucrats trying to move forward with. So that would be my choice. Okay. We have to, next thing is call to the public. I'm going to jump jumped onto that item, call the public. Is there anybody that would like to address the task force or items that, go ahead. Andrew, come on down to the podium if you would, please.
Okay, I have 2 minutes here. Let's give you guys a report. Okay, so I'm Andrew Wisher, and I'd like to first thank you guys for allowing me to speak and for what you guys are doing. I am the current president of the Arizona Pest Professional Organization, and been in the pest management industry 8 years, and now on the AZPPO's board for 3 years next month. Also general manager for Scorpion Tech and Qualifying Party, small business with 8 employees. So at the February meeting, town hall meetings, or at this meeting, we're going to be summarizing 2 town halls that were held in Phoenix and Tucson. And today I'd like to share with you the results of town hall meetings that we held on March 31st and April 1st as part of our AZPPO annual conference and trade show. We estimate that over 65 people were in attendance at one of each of these meetings. And the purpose of these town hall meetings was to discuss the OPM Task Force draft rules and statutes. So notices of these meetings were sent to over 1,000 licensed applicators via email, and in attendance at both locations included businesses of all sizes. And then we express thanks to Jack Peterson for making the time to come out here and present the statute of changes. The Phoenix Town Hall was attended by more than 15 people, and kind of low attendance. Some of the comments included, no exception should exist from business license for apartment owners, schools, businesses providing consumer benefits with application of pesticide. The proposed education experience options as a starting point. Support the QP's ability to broaden the needs of the TNO by simply taking a test. Concern with allowing QPs to broaden the tournament category without practical experience. Need for OPM to address QP broadening concerns by developing a more stringent testing protocol. A definite benefit of developing field testing for QP's broadened license. In favor of keeping costs lower, fee, and reducing the amount of information reported. Allow the consumer to get information from the specific company. And in fact, I would say it's probably safe to conclude that in both locations there was unanimous consent that $8 TAR fee is not.
All right. We're at 3 minutes.
Too much.
You're at 2 minutes. So.
I'm done.
Okay.
Thank you guys.
Thank you. Good.
I'll just make a quick comment on that summary.
Come down,
Henry.
please.
If you listen to the videotape of the Tucson Town Hall meeting, you'll notice that the word TARP was never mentioned a single time, so your summary is dramatically inaccurate. All you would say.
Anyone else? Okay, with that, we need to look ahead to the next meeting. I think it may be, we may be down at least one number. I think is what I'm legally going to do. Okay. So we're looking at May. This is the week of May. If we go a month out, it's like the week of May 14th, and we already know that Will Rousseau is not going to be here.
I can't do the 16th.
What country is he going to be in that?
DC.
16th doesn't work for you, Ken? I'd rather leave it that middle week. It gives us the maximum amount of time to get things out and prepared. Otherwise, it cuts the time short for us to. Could we?
And gave us Mac Jack.
How about could we do it on the 15th?
May 15th?
Yeah, May 15th. Nothing? Anything jumping out at you guys? 15th? Okay, we'll schedule the next one for May 15th. And tentatively, we'll look at in the ADA building. We don't get kicked out again, and but we'll get the notice up and a draft agenda fairly quickly as we have been for these meetings. So with that, it'll be at 10 o'clock again in the morning. So thank you everybody for coming. I really appreciate you spending the time here and listening in and providing your input. So we'll see you again. Don't forget there's a PMAC meeting this afternoon. So if you would like to stick around for that, it's going to be the same location. Meeting adjourned. Thanks. All right.
said the 5th.
Yes, sir.
All right, throw us all off our